Your Excellencies, dear all, a very good evening to you. It's wonderful to see that we have a full house, and this is not even taking into account our friends and colleagues joining us online from abroad, especially from Ukraine, of course. My name is Christophe Paulussen, and I'm a senior researcher and strength coordinator here at the T.M.C. Institute, and I would like to warmly welcome you at the very first Supranational Criminal Law, or SCL Lecture, of the new academic year, entitled Pursuing Accountability for the Crime of Aggression Against Ukraine. And the SCL Lecture series is a series on international criminal law and has been organized since 2003 by the T.M.C. Institute in cooperation with the Coalition for the ICC and the Grotius Center for International Legal Studies of Leiden University. And tonight's lecture is moreover co-organized by two other entities, namely the International Humanitarian and Criminal Law Platform, which is an academic network coordinated by the Astrid Institute on IHL and ICL, in which 13 institutions from the Netherlands and Belgium participate, as well as the Embassy of Ukraine in The Hague. And I would like to use this opportunity to thank the Ambassador, His Excellency Mr. Oleksandr Karasevych, as well as Maria Bezdinishna for co-organizing and co-hosting this event. I would also like to thank the Municipality of The Hague, today represented by Hilde Marij Mesker. I don't know. Yeah, she moved there, for their financial support. On the 4th of May of this year, when he visited The Hague, Ukrainian President Zelensky spoke about the pursuit of accountability for international crimes committed in Ukraine. And he then remarked, only one Russian crime led to all these crimes. And this is the crime of aggression, at the start of evil, the primary crime. There should be a responsibility for this crime. Even though Ukraine can prosecute individuals for the planning, preparation, or waging of an aggressive war or armed conflict, or conspiring for any such purposes, as well as conducting an aggressive war or aggressive military hostilities, and this is mentioned in Article 437 of the Criminal Code of Ukraine, the framing of this provision and the issue of personal immunity would make prosecution in national courts of high-level foreign officials such as Putin complicated. Moreover, the ICC does not have jurisdiction over the crime of aggression in the situation, as both Russia and Ukraine have not ratified the Rome Statute, and the UN Security Council will not refer the situation to the ICC because of Russia's veto. So, as a result of this, discussions on establishing a tribunal for the crime of aggression have been gaining momentum, and one of the topics under discussion among both politicians and policymakers, but also academics, is the exact model that this tribunal could and should take. So, for example, during the same visit to The Hague, beginning of May, President Zelensky clarified he wanted a fully international criminal tribunal and not a hybrid or internationalized model, so a court rooted in Ukraine's judicial system, but including international elements as well. And this is the model advocated for by US Ambassador at Large for Global Criminal Justice, Bert van Schaak, a few days earlier. Now, in this SCL lecture, interestingly taking place, by the way, on the International Day of Peace, these different models, as well as any other mechanisms that could be considered in pursuing accountability for the crime of aggression, will be critically explored. And I'm thrilled that we were able to bring such an excellent panel together, not yet complete, but hopefully then the final panelists will also join us soon on such an important topic. But before I will introduce to you our panelists, I would first like to give the floor to His Excellency Mr. Oleksandr Karasevych, the Ambassador of Ukraine to the Netherlands since June 2023. And in 2003, he joined the Consular Department of the Ministry of Foreign Affairs of Ukraine. He continued his diplomatic career in the Consulate General of Ukraine in Toronto as a consular officer. And in 2009, Mr. Karasevych joined the international cooperation team in the presidency, overseeing international legal as well as various bilateral and multilateral issues. And from 2017 to 2021, he worked in Strasbourg as a deputy permanent representative of Ukraine to the Council of Europe. And in 2001, he returned to the Ministry of Foreign Affairs. And after a brief period of work as director for international organizations, he was transferred to the Office of the President of Ukraine, where he led the Directorate of Foreign Policy and Strategic Partnership. So, Mr. Ambassador, thank you so much for your cooperation in co-organizing and co-hosting this lecture, and you have the floor.
Thanks a lot. Thank you very much for this presentation. So you do understand that I am a diplomat, not a lawyer, so I'm not going to intrude into your sphere. But first of all, Let me thank all of you. Ladies and gentlemen, I am really grateful for you being here today, because yes, for discussion we need panelists, but we also need audience. Thank you. And we're also thankful to the Institute for organizing this event, and also to every partner whom you see there. Without you, it won't be possible just to be here today and to discuss this really important topic. Russian brutal aggression is reshaping international legal order, and we as diplomats and you as lawyers cannot opt for just watching it happening. You have legal tools in our hands, and there should be no other choice but to be strong and decisive in combating this evil. Today is September 21st. It's not just a date, actually it's the International Day of Peace established by the UN. And I would like to underline once more that no other country actually strives for peace more than Ukraine. However, for us, for Ukraine, for the people of Ukraine, peace is not only the cessation of hostilities. This is, first of all, just peace and sustainable peace. It is for this peace we fight today, both at the battlefield and in the courtrooms. The principles for a just and lasting peace are has been outlined by the President Zelensky in his peace formula. And an important part of this formula, the prerequisites of just peace, is comprehensive punishment for all war criminals. Of course, it is also compensation for losses and damages. And last but not least, it's the punishment for the primary crime of aggression itself. Of course, international law provides Ukraine and all of us, international community as a whole, quite a number of tools to achieve this just peace. In Ukraine, we do highly value our cooperation with the International Criminal Court. We do appreciate launching of the International Center for Prosecution of the Crime of Aggression against Ukraine, and of course the Register of Damages established under the umbrella of the Council of Europe. However, unfortunately, still we do not have all the answers. For instance, punishing Russia for the crime of aggression seems to be one of the most difficult tasks for modern practitioners and theorists of international law. And it is a daily work to search for these right answers. And I'm glad that you are all here today to discuss different models we have enhanced, different mechanisms for pursuing accountability for the crime of aggression against Ukraine. International law architecture is designed to hold the international community on its pillars. And I do believe that not finding answers to the most difficult questions means to undermine these basic pillars. And I'm afraid that we will not be really happy about such possible consequences. Punishing for committing co-crimes must be alpha and omega for the post-aggression international legal order. And it is really our common responsibility not only before ourselves, but before our nations and before the next generations. So I really would like to wish you fruitful discussion today. Thank you.
Thank you very much. We now turn to our panel, starting with our keynote speaker, Dr. Anton Korynevych. He's a Ukrainian lawyer specializing in public international law, IHL and ICL, serving as ambassador at large in the Ministry of Foreign Affairs of Ukraine since the 25th of May 2022. And Dr. Korynevych has been working on the legal consequences of Russian aggression against Ukraine since February 2014. For example, he is the agent of Ukraine before the International Court of Justice in the allegations of genocide and the application of the International Convention for the Suppression, the Financing of Terrorism, and of the International Convention on the Elimination of All Forms of Racial Discrimination cases. And moreover, he's a member of the working group on the development and implementation of international legal instruments of reimbursement of damage caused to Ukraine by armed aggression of the Russian Federation within the Office of the President of Ukraine. He's also a member of the working group on the establishment of the Special International Tribunal for the Crime of Aggression against Ukraine, also within the Office of the President of Ukraine. And he's a member of the International Advisory Board of the Prosecutor General's Office of Ukraine. And finally, Dr. Korynevych is coordinating the issue of the establishment of the Special Tribunal for the Crime of Aggression against Ukraine in the Ministry of Foreign Affairs of Ukraine. So Dr. Korynevych, we already had the pleasure of welcoming you here at the Institute in November last year to talk about these important matters, but we much appreciate that you've also found time in your very, very busy schedule to participate also in this public lecture. You have the floor.
Good evening, dear colleagues. Thank you so much, Dr. Paulussen, Ambassador, for this possibility to talk today to such a big audience. And I think that it means that people here in The Hague are interested in the issue which we're going to discuss. And this is, of course, very important for us in achieving our goals. And of course, I'm grateful to all the organizers of this event for making this happen, as it is really important to talk about accountability for the core crimes committed on the territory of Ukraine and against Ukraine. And of course, it is also important and a pleasure for me, because I'm also a university associate professor trying to combine everything in one head, not always dealing good with that, but I'm trying to do my best. Since we are talking today about pursuing accountability for the crime of aggression against Ukraine, I will use my time in order to briefly talk about the road to ensure accountability for the crime of aggression against Ukraine, what has already been done, what still has to be done, what are the challenges and what are the tasks for us to pursue our goal. And it is a big pleasure and honor for me to see a lot of our friends and colleagues in this room with whom we do this together. So I'm sure that with our friends and colleagues, we will make this happen. So as you all know, the crime of aggression is one of the 4 core international crimes, which was the principal international crime for which the international military tribunals in Nuremberg and Tokyo worked. And then it was labeled as a crimes against peace. But then for several decades, it was left out of scope of the work of international criminal tribunals due to several particular reasons, sometimes legal, sometimes political. But it is the case that after 1945, 1946, 1947, and 48, the crime of aggression was not there in the jurisprudence of international criminal courts and tribunals. And that is why it is really not so easy to work now on the establishment of accountability mechanism for this crime. But also it is understandable for us in Ukraine, in Kyiv, that in our particular situation, it was, as Mr. Ambassador said, the primary crime, the very core reason, the root cause of all the other core international crimes committed on the territory of Ukraine. War crimes, crimes against humanity, a lot of genocide. We understand that in different other contexts, in different regions of the world, there were, let's say, non-international armed conflicts where the crime of aggression was not committed, but war crimes were taking place. But in our particular reason, and I'm saying this as a Ukrainian who permanently lives in Kyiv, whose family is in Kyiv, and I know what my country faced. So before February 2014, Ukrainian legal system, Ukrainian judicial system didn't know what is a war crime, what is a crime against humanity, because we never had experienced that. And the aggression of the Russian Federation started in February 2014, and we unfortunately started to see this firstly in Crimea and Donbass, and now with this full-scale invasion on all the territory of Ukraine. So we consider that it is crucial for us to ensure accountability for this crime, for the crime of aggression, for the root cause, which brought all the other international crimes to our soil. And it was also important for us that since 2014, as Dr. Paulussen mentioned, we worked in each and every possible international court and tribunal to bring Russia and its citizens to accountability. So we have cases against Russia in the International Court of Justice, the two named cases. In the European Court of Human Rights, we recognize jurisdiction of the International Criminal Court. We have two cases in the arbitral tribunals established under the United Nations Convention on the Law of the Sea. So each and every existing mechanism and tools we are using, but we see that we have gaps in this accountability system. And in order for us to be sure that justice and accountability prevails, we believe that we need to cover those accountability gaps. And then we will be able to say that we secured and ensured the full and comprehensive accountability under international law. What are these two gaps? The two gaps for which mechanisms still do not exist. The gaps which relates to the reparation and compensation of damages caused by the Russian aggression. And here, the named by Mr. Ambassador register of damage is established as a first element, but still we need a compensation mechanism which will be able to do the job on the basis of the data provided by the register of damage. And the other gap is accountability for the crime of aggression. Moreover, we understand that the crime of aggression is a direct route to those who engineered this war, who still gives order and gave orders to attack my country, to commit this aggressive war against Ukrainians. So we looked at the situation, and in the end of February 2022, we started to actively work on this matter, on the possible establishment of a special tribunal for the crime of aggression against Ukraine. We understood that this is not an easy task. And we also understood that this task, this goal, might be perceived with different reactions from different angles, from different experts. And in the beginning, in the end of February 2022, in the beginning of March 2022, we had different feedbacks. We had different reactions. Sometimes people told us, Ukraine, you shouldn't try to invent something new. It's very hard. International legal system is settled. You need to use the mechanism which you have. Our answer was that we are already doing this, but we see that this is not enough. And we need to try to do the job. And so we started to do this job, of course, together with our friends and partners, with assistance of our colleagues, experts, lawyers, diplomats from other states. And as of now, I think we reached pretty good interim results on the way to ensure accountability for the crime of aggression against Ukraine. Of course, the ultimate goal is to establish a special tribunal, because when we talk about accountability mechanism, this is a court, this is a tribunal, which would have jurisdiction to prosecute persons for the commission of the crime of aggression against Ukraine. But in order to reach this goal, we already reached some good interim provisional results. The main of them is the establishment of the International Center for the Prosecution of the Crime of Aggression against Ukraine, which is situated just next door in Eurojust, and which is the first international effort in relation to investigation and prosecution of the crime of aggression in case of its real perpetration after the Second World War. So that is why I do believe that those who are interested in international law, in international criminal law, we do need to value ICPA and its importance, and we all need to work for ICPA to be an effective body of investigation and prosecution. Apart from ICPA, we also have quite good level of political support of our endeavor. In particular, when we talk about resolutions of parliamentary assemblies of international organizations, Parliamentary Assembly of the Council of Europe, Parliamentary Assembly of NATO, Parliamentary Assembly of OSCE, European Parliament, which adopted a lot of resolutions in favor of our endeavor, Parliament of National States, and many, many other political support with statements, with declarations, with addresses, which we see pretty much happening from time to time and quite often. It is also important that on the way to the establishment of the special tribunal, we gathered a core group of states, which now enlists 38 participants. And we do value this platform very much, because this is a very important platform for us to exchange views, to talk about legal and technical issues, which we hope soon will get us to the result. And this result, of course, is the establishment of the Special Tribunal for the Crime of Aggression against Ukraine. If you would ask me in beginning of March 2022, whether we may get all of this in September of 2023, I would, of course, say yes, because I feel optimistic on this point, but still, I think these are really very good results on which we can build on our further work. Of course, the issue is not simple. And as many of you are aware, there are two main possible models or options or formats for the establishment of the special tribunal. The one is about establishment of the special tribunal on the basis of the agreement of Ukraine and the United Nations, with the relevant resolution adopted by the UN General Assembly, which would authorize the United Nations, in particular Secretary General, to enter into agreement with Ukraine for making such an agreement happen. In such a case, such a tribunal would be purely international, would have international legal personality, will not be part of legal system, of judicial system of any state, and it is a high possibility that it can be effective one. And when we say so, we mean that it will be able to overcome both functional immunities of state officials and also personal immunities of the highest officials, so-called troika, the head of state, head of government, and the Ministry of Foreign Affairs. The other option format, which is also being discussed, and Dr. Paulussen mentioned this is the internationalized, or it can also be framed as hybrid tribunal, which brings its nature from national legal and judicial system of Ukraine, and which is organized on the basis of Ukrainian law, but with sufficient international elements. What these elements may be, for instance, relocation to some third state, international judges, international prosecutors, and many other possibilities for inclusion of international elements. There are friends and partners who support variant A, there are friends and partners who support variant B. For us, for Ukraine, it is crucial that the thing which we established can be as much international as it can be, for us all to be able to say that this is not a one country response for the aggression against itself, because we all understand that this is the issue of, let's say, independence, of impartiality, and a victim state trial against the aggressor may not be seen as something independent and impartial enough. So, of course, we want this tribunal to be as international as it can be, in order to be an effective, a solid, a legitimate tribunal which will be able to do its job. I don't think that I will talk more about the formats and options. We have great professors here on the panel. My job is to make special tribunal happen. It's not an easy job, but I'm sure that we will do this, especially when, again, we look at the results which we got on this way throughout this 1 year and a half. It is also important to understand, and it's really important to flag this here in The Hague, that our Ukrainian endeavor to establish a special tribunal, it doesn't mean that we want to impede or hamper the investigations in the International Criminal Court. Ukraine actively and effectively cooperates with the International Criminal Court. Just recently, several days ago, the field office of the ICC was opened in Ukraine. Ukrainian prosecutors have permanent contacts with the colleagues from the International Criminal Court. Ukraine's legislation was amended in order to make the work of the ICC more efficient in Ukraine. In particular, this deals with the Criminal Procedural Code of Ukraine, which now includes a separate chapter on the cooperation of the ICC. So ICC is a priority for us. We understand its importance, and we want to see more arrest warrants for Russians. It is a historical moment that we have arrest warrant for a head of state, sitting head of state of UN Security Council permanent member. I don't want to call his surname, but it is the International Court of Justice. But we consider that there must be more arrest warrants from the ICC in relation to the Lodge Commission of War Crimes, crimes against humanity, and the crime of genocide. But we do understand that without the responsibility for the crime of aggression, the system will not be full. We will not punish the root cause. We will punish only the consequences, how hard they be, of course, but we need to tackle the very basis of this absolute Russian evil. So that is why we will pursue this goal, again, without any intention to impede or hamper or interrupt within the investigations of the International Criminal Court. And in this relation, I think there are also a lot of processes in international law which are important and which are a bit on the side, don't relate particular to the issue of ensuring accountability for the crime of aggression against Ukraine, don't relate particularly and concretely to the issue of the special tribunal, but which are important. For instance, a lot of people in this room are aware about draft articles produced by the International Law Commission on the immunity of states from foreign criminal jurisdiction. And when we open that document, we see draft Article 7, which actually says that for the crime of aggression, persons enjoy functional immunity. So if this would be the rule of law and the norm, which would become a treaty or even adopted articles, which may be then cited by judges within the courtroom, it might mean that Sergei Shoigu, Valery Gerasimov, Valery Zolotov, so all those commanders of Russian Ministry of Defense and Russian Army cannot be tried by any tribunal for the crime of aggression because they have functional immunity. I'm not talking now about those troika who has personal immunities. This is another part of the story. But here we talk that if the functional immunities for the crime of aggression apply, then any kind of tribunal will be able to do nothing. It will be a useless tool. And since now it is a high time for the deliberation on this point, we as Ukraine's government, we will of course use this opportunity. I think it's a high time to change the perception and to make it the rule of law and the norm of law that functional immunities should not apply for the crime of aggression, as they shouldn't apply for the crime of genocide, for the crimes against humanity, for war crimes, for all the other co-international crimes. So I think that here in this conversation about pursuing accountability for the crime of aggression against Ukraine, these from the one side, they may be called side topics, but still they are very important for us to achieve our goals. So that is why, as I said, we as Ukraine's government, we would of course present our observations, and we consider that the crime of aggression should not have this exception in relation to other three core international crimes. I think I will finish now with one sentence or one thought, which is really deeply in my head, in my mind, when I'm thinking about the crime of aggression against my country, against our people, and the international legal response to this aggression. I really think that in this moment of history, when we have the Russian aggression against Ukraine, which is being recognized as aggression in the United Nations General Assembly resolutions by pretty much all the key international organizations in the world, if we do not have a mechanism for bringing perpetrators of the crime of aggression to responsibility, crime of aggression will be not real for international law. It will remain for textbooks, for PhD theses, for papers by students, but it will never become real for international law to work with. So I think that that is why we united our efforts, and I'm sure that we will surely make this happen. Thank you.
Very
very much for this clear, and I would also say realistic overview of the legal battle that Ukraine is still fighting. We now turn to our respondents, and the first person I would like to introduce to you is Professor Larissa van der Herik. She's Professor of Public International Law at the Grotius Center for International Legal Studies of Leiden University. And moreover, she's the former chair of the Advisory Committee on Public International Law until February of 2023. And in that capacity, she also advised the Dutch government on the challenges of prosecuting the crime of aggression. Also, this draft Article 7 was mentioned in that report. So, like all the others, Professor van der Herik has a much longer and very impressive CV, but she asked me to introduce her in the shortest way possible so that she has more time for her own intervention. So, Professor van der Herik, take it away.
Thank you. And thank you in particular, Dr. Korynevych, for your enlightening perspective of the road towards accountability for the crime of aggression and the steps already taken. I think the efforts of Ukraine, and particularly of you as the ambassador of Ukraine and its agent, to make sure that justice will be done also for the crime of aggression are impressive. So last week, we had the great privilege and honor to have President Zelensky speak online to the students of Leiden. And in his speech, above all, the president called for unity. And I think that this is a call that we should keep in mind when we embark on our discussions tonight. So unity is not a given in today's world, as your president very clearly underlined. The Russian aggression against Ukraine was condemned, indeed, by the UN General Assembly, by many international organizations, also the G7, so quite some unity there. The Bali Leaders Declaration of the 2022 G20 meeting, chaired by Indonesia, also recognized that most G20 members strongly condemned the war in Ukraine, against Ukraine. Yet, the G20 New Delhi Leaders Declaration of 2023, issued just last week, does not include a similar condemnation. It merely notes that the G20 is not a platform to resolve issues of security, and it is otherwise silent on the Russian aggression. So the discussions on accountability for aggression and the creation of a special international tribunal for aggression take place in quite a rough geopolitical climate in which some states have actually expressed quite clearly that they have reservations about the idea of accountability. And that group of states includes, unfortunately, even states that are party to the ICC. So in this climate, that some call a geopolitical winter, where some states are hesitant about accountability or even about condemning a blatant violation of the most important norm of our international legal order, in that climate, I think it is imperative for those who do believe in international law, who do believe in accountability, to hold hands. So precisely because there is no unity at the global level, we must strive for unity within the accountability camp. Now, states and scholars within this accountability camp, they're united in that they all subscribe to the core idea of accountability, but they have different ideas on how to get there. So I think the main question for us tonight is, how do we achieve unity within the accountability camp? And I think it's a very important question to ask, because there is a risk of continuing a conversation on form of the tribunal and immunity that may eventually result in a deadlock while the world moves on and momentum is lost. So yes, the big issues on the table are immunity and mode of creation, or institutional form of the tribunal, which are interrelated issues, but possibly not as interrelated as is sometimes suggested. Now, on immunity, firstly, it is important, and I think that was very clearly remarked in the keynote as well, to distinguish very clearly between personal immunity and functional immunity. On personal immunity, we are often confronted in the debate with this dichotomy. International immunity, personal immunity, international tribunal, no personal immunity, national tribunal, personal immunity does apply. But I think this dichotomy is too simplistic. It is too simplistic for two reasons. Firstly, international tribunals come in all forms and shapes. They can be created by the UN Security Council. They can be established by a treaty with 100+ state parties, a treaty between the territorial states and the UN or a regional organization. And an international tribunal can possibly also be established by bilateral treaty. Now, the discussion on personal immunity has different legal dynamics for these differently established tribunals. So, for instance, Setting aside personal immunity of a head of state by an ad hoc tribunal created by the UN Security Council can be justified by reference to Article 103 of the UN Charter. But that justification does not work for an international tribunal established by a treaty. So saying that immunity does not apply because a tribunal is international is too simple an argument. Secondly, conversely, I think the dichotomy does not work because it is not entirely inconceivable that an argument can be made that immunities do not apply before a national tribunal rooted in domestic jurisdiction, if that national tribunal is vested with strong international elements and has been granted international endorsement of some sort, an international national tribunal. So I argue that the issue of immunity is not linked to establishment per se. It can conceivably be connected with international endorsement in a different way, for instance, endorsement of a tribunal by the UN General Assembly or a sufficiently widespread representative group of states, the requirements for new customary international law. Such an endorsement can, in theory, recognize a tribunal as an agent of the international community, and then, as such, it can set aside personal immunities. So, of course, this isn't maybe you can say extravagant arguments. And there are many questions. How many states must endorse or vote in the General Assembly? How specific must the endorsement be? And since it is quite an exceptional argument, I would say that the bar must be set very high for the argument to retain credibility. But all this goes to show that the discussion on immunity, and specifically personal immunity, is much more layered than sometimes presented. Then on functional immunity. I would like to refer to an outstanding report of the Dutch Advisory Committee of Public International Law. And I can say that because it was published after that I was the chair. I chaired the committee until February of this year. This report came out after, under the leadership of the new chair, Professor Cédric Reinigaard, and the vice chair, Professor Rosanne van Alebeek, who is one of the authors, and she's also present here tonight. Now, core elements of the new advisory report on immunity of state officials include two. Firstly, the advisory committee finds the arguments for the existence of an exception to functional immunity for the prosecution of crimes under international law legally convincing, as lex lata. And this actually it already remarked in its advisory report of 2011 and 2022, the report that you referred to. Secondly, the Dutch advisory report makes an argument against a list of crimes to which the exception applies. It suggests instead to formulate a more general rule which bases the exception of functional immunity on the existence of individual criminal responsibility and universal jurisdiction under customary international law. So that leaves the door open for aggression, provided that we accept that universal jurisdiction can be exercised for aggression, which is a whole discussion on its own. So there's a lot to say about immunity, also functional immunity. And it is indeed going to be very important to see state reactions to the work of the ILC and discussions in the 6th committee. But my main point for tonight is this. I agree with you that what must be done now is to create a legitimate and credible justice mechanism that has as much international support as can be. The issue of immunity does not have to be, and possibly cannot be, predetermined by the negotiators establishing the tribunal. It can also be left pending for the judges to decide who will, in any event, adjudicate the matter independently. Now, very briefly, two other points on unity. Firstly, on unity of the definition. So in parallel with this possible special tribunal for aggression, we see preparations for domestic prosecutions in Ukraine and possibly also in other jurisdictions based on universal jurisdiction. I want to flag here the importance of unity of definition. If there are domestic prosecutions based on a very expanded definition of aggression that ignores the leadership element or interprets it very widely, this undermines the strength of the crime of aggression as a norm under customary international law. So it is important that state parties to the ICC and also Ukraine, which has the firm intention to become a state party to the ICC, that they interpret their domestic definitions in light of the ICC statute, and specifically that they adhere to the ICC leadership requirement, which is rather strict. Now, if there is a desire to prosecute more people for aggression, also those that seem to fall outside a credible interpretation of the ICC leadership requirement, this can be done through other forms of accomplice liability and co-responsibility, where the leadership requirement does not necessarily need to be applied. Now, the ICC statute, yes, it does require the leadership requirement for these other forms of responsibility in Article 25, paragraph 3 bis, but generally states attach their own domestic modes of liability when implementing the ICC crimes. And I think that can also be done for the crime of aggression. So in short, I advocate that states stick to a credible interpretation of the leadership requirement for the principal perpetrators in domestic prosecution to the extent that they will prosecute those, while the net can be spun wider for accomplices, That would ensure a coherent, a consistent, and a unified approach to the leadership requirement in the substantive definition, reaffirming that the crime of aggression is a clearly defined crime under customary international law, while the aim to prosecute a larger group of people can be legally met through this wider approach via other modes of liability. So lastly, on unity of the system, I would say that the discussion on the Special Tribunal for Aggression that we have tonight must go, and you said it, hand in hand with bringing more unity in the system. And for that reason, I commend the proposal also put forward by the Global Institute for the Prevention of Aggression that seeks to harmonize the conditions under which the ICC can exercise jurisdiction, so to bring the ICC in line with the other crimes. I think that's of vital importance to prevent, in any case, moving forward, the selective prosecution of aggression. So there's a lot of work to be done, but I leave it here for now. Thank you.
Thank you very much, Professor van den Herik. I think not only for explaining these more technical issues about immunity, but also for stressing the fundamental importance of the notion of unity. That, by the way, will also come back later in this panel. So, now we turn to our next respondent, Professor André Nollkaemper. He is the Dean of the Faculty of Law at the University of Amsterdam, where he has also been Professor of Public International Law since 1998. And in 1999, he established the Amsterdam Center for International Law, ACIL, which has become a center of excellence at the University of Amsterdam and ranks amongst the top institutions for international law in the Netherlands. In 2012, he was elected as lifelong member of the Royal Netherlands Academy of Arts and Sciences. And in 2017, he was elected as a lifelong member of the Institut de Droit International. And between 2010 and 2020, Professor Nollkaemper was external legal advisor to the Minister of Foreign Affairs of the Netherlands. And he was also a member of the Permanent Court of Arbitration and president of the European Society of International Law. Now, Professor Nollkaemper is a leading scholar in international law and has published and commented on a wide variety of topics, including on the Special Tribunal for Aggression. Professor Nollkaemper, you have the floor.
Thank you very much. So it's an honor and a privilege to speak on this very important topic. So let me zoom out a bit and start with the key element that indeed we should treat and continue to treat aggression as a leadership crime in that very narrow definition. So really only persons who are in a position to effectively control or to exercise direction over the political or military actions of a state are within the scope of that crime. And I think it's key to keep that always in focus. So that defining feature also makes that the crime of aggression, by its very definition, is a crime that triggers a double responsibility of the state of the Russian Federation and responsibility of the leadership of the Russian Federation. Now, there's no doubt that from the perspective of the interest, the legal interest of Ukraine, its citizens, and indeed of the international legal order, it is vital that states the international community cooperate to bring to an end and create accountability. This is not just a political desirability. It is a norm of international law that a transgression of a peremptory norm of international law like aggression is met with the obligation to cooperate to bring to an end and to create accountability. Now, we should not blind ourselves, before I get to the tribunal, that any attempt to create accountability for the leadership crime hits on three fundamental limitations of international law that we cannot simply get around. And the first, as the elephant in the room, is of course the veto power of the Russian Federation in the Security Council that blocks what would have been the most appropriate responses to aggression as defined under the Charter of the United Nations. And the second, that we also cannot get around, is the absence of compulsory jurisdiction of the ICJ over aggression. And the current case in the ICJ, under the frame of the Genocide Convention, is important, should be followed with all energy, but it will not be able to frame the topic as it is, as a crime of aggression. And that is not just a technicality that blocks accountability of the Russian Federation as a state, but it also raises the fundamental question, who determines eventually the existence in legal terms of a situation of aggression? And the third limitation, on which we already have spoken, is the personal immunity of the leadership of the persons who made possible and indeed committed the crime of aggression, in particular the President of the Russian Federation. So no legal construction for setting up a special tribunal other than a resolution of the Security Council will be able to overcome that personal immunity. And on that, I'm perhaps a bit stricter than Professor van der Herik, but we can debate it perhaps later on. So we cannot get around the fact that as a result of an agreement made 77 years ago, the leadership that is in the core of the definition of aggression will be able to get off the hook of a legal determination of responsibility. Now, none of this, of course, makes the importance of setting up a special tribunal any less important. Because the special tribunal will contribute to the determination and implementation of at least a partial responsibility for the crime of aggression, partial in the sense that it may indeed bring to justice perpetrators just below the highest level of leadership of the Russian Federation. The question of functional immunity that then will be faced is indeed a serious one if one reads the IOC work carefully. It is my firm impression, also looking around the state practice around the world, that this is an area where the state of international law has been very much in flux. And even in the Netherlands, cases have been going back and forth on functional immunity. And if the law is in flux, it also means that any court, certainly a hybrid court or an international court, is in a position, arguably even has the responsibility, to continue to the development and the progressive development of the law. So the special tribunal, if established with a mandate to prosecute persons, state agents, who normally would have functional immunity for the crime of aggression, is a path to go, but only, and there is the connection with the method of setting it up, but only if it is set up with a broad support of the international community. So I would think that the combination of the broad political support that Professor van der Herik also referred to, condemning the crime of aggression on one hand, and second, the obligation to cooperate of the international community for a transgression of a peremptory norm of international law, if supported by a sufficiently wide majority of the General Assembly, definitely will bring the special tribunal in a position to contribute progressively to the development of international law by denying functional immunity for persons suspected of the crime of aggression. Now, we have to realize, that's my last but still quite fundamental point, that this will only bring us halfway through accountability for the crime of aggression. And if you want to go beyond that halfway route, there's only one path, and that's the path addressed by President Zelensky this week in New York, which is a reform of the Security Council. So I would very much hope that in addition to the support for setting up a tribunal, a special tribunal, that might lead to a change and a recognition of the absence of functional immunity for state agents, it also will be the trigger to set in motion to set again in motion the process for reform of the Security Council, which should consist of two components. One, a widening of the membership of the Council. Two, a removal of the veto right of single permanent members of Security Council that until now, and that will block true accountability for the crime of aggression in Ukraine. Thank you very much.
Thank you very much, Professor Nollkaemper. I already look forward to the discussion between you and Professor van der Herik about the UN Security Council versus the UN General Assembly, but that may become later at the Q&A. We now turn to Dr. Astrid Reisinger Coracini. She's a senior lecturer and researcher at the Institute of European, International and Comparative Law at the University of Vienna. And her research focuses on sources of international law, the use of force, IHCL, and the international protection of cultural heritage. And previously, Dr. Reisinger Coracini served as director of the Salzburg Law School on International Criminal Law, Humanitarian Law, and Human Rights Law, and held academic positions at the University of Graz and Salzburg. Dr. Reisinger Coracini participated in the negotiations of the Special Working Group on the Crime of Aggression and has been a member of the Austrian delegation to the Assembly of States Parties and the first review conference of the Rome Statute of the International Criminal Court in Kampala. There's more to be said, but in view of the time, I think this suffices. So thank you so much again for being with us tonight, and you have the floor.
Thank you very much, Christophe, for this very kind introduction. I already got a lot of food for thought, but I will try to stick to the message that I wanted to get through, and but maybe I need to incorporate some remarks. I wanted to comment on three issues, the main one being the question of the model of a possible accountability mechanism for the crime of aggression. But I would also like to very briefly at least comment on a question that has already been raised by my previous speakers, the question of functional immunity and the work of the International Law Commission in its draft articles on the immunities of foreign state officials. And thirdly, at least very briefly, I would also like to comment on the broader notion that was also brought into play already with the reference to a recent proposal of the Institute for the Prevention of Aggression to amend the Rome Statute. And I think any discussion on a special tribunal or on the accountability for the crime of aggression must go alongside the question of how to amend the Rome Statute. And if we are talking about closing a gap in the enforcement of the crime of aggression, we cannot only look on the present situation and the situation in Ukraine, which is of course the most relevant and pressing time-wise, but we also need to look in the future and how to prevent similar situations in the future, that we're not sitting here again in 10 or 20 years and discuss again, should we establish a special tribunal, should it be internationalized, or should we use another jurisdiction? Now, allow me first to comment on the question of an accountability mechanism for the crime of aggression committed against Ukraine. So my first point would be very simply, there must be one. And I think this echoes also what the previous speakers have said. unity, achieving a common goal, this crime of aggression against Ukraine cannot remain unpunished. And I've thought of one example from the negotiations of the crime of aggression in the context of the Rome Statute. And those of you who are familiar with the negotiations might remember that there was a rather extended discussion on what should be the point of reference of the crime of aggression to the underlying act of state. Should it be a war of aggression, following the Nuremberg example, or should it be an act of aggression, which would be the more modern terminology that was used in the Charter of the United Nations, and arguably is a broader notion. And there was one proposal that tried to bridge the gap by trying to formulate the essence of what constitutes a war of aggression in more modern UN Charter terms. And that proposal was basically referring to an armed attack against the territorial integrity or political independence of another state with the object or result of establishing a military occupation of or annexing the territory of such other state or part thereof. And I'm referring to this because this is a very narrow proposal, and it did not gain broader support because it was understood that it narrows too much the customary law understanding of the definition of aggression. But it was also understood that this definition would never be applied because this type of wars does not exist anymore. We are not in the state of empires where we fight wars to gain territory. So just to bring this into this discussion, because now we are exactly faced with this type of a war of aggression against the very existence of a state. So something that was thought would not even exist. So if we do not act on this basis, where even one of the most narrow definitions that have come up in the process of negotiating the crime of aggression is fulfilled, then really the question that we need to pose is whenever would we prosecute this crime? Now, I fully agree with the contours of that have been outlined as how such a mechanism could look like, and in particular, what are the main objectives? So we are looking at a mechanism that looks into events that started in 2014, the start of the aggression against Ukraine. And I'm trying to avoid using the term Russian aggression, not for political reasons, but because there are other states that are also involved in this aggression against Ukraine. So far we have one, but we do not know where this is going to develop. So the time frame of 2014, cooperation with the International Criminal Court that is investigating in the situation, a tribunal that would complement the work of the ICC, and ideally a tribunal that would be able to prosecute all perpetrators, all alleged perpetrators of the crime of aggression. And with that, we are coming back to the question of immunities. Maybe I will start with personal immunities. And if I follow up to what Professor Nollkaemper just said, yes, the international legal system is limited. And in particular, when we have the use of force by a permanent member of the Security Council, we reach those limits. There will not be an establishment of an international tribunal by the Security Council. And I think we can safely say there will be no consent or waiver of immunities by the Russian Federation or any other state that may be concerned. But the question is, do we really need to stick with it? Is this really all? And I was arguing in different fora for possible ways of how to overcome the question of personal immunities. And I don't feel completely alone here when we look at the International Criminal Court that issued an arrest warrant against the sitting head of state. And if we really have such a narrow focus on only accepting international tribunals established, or in the context of the ICC, it would be a referral by the Security Council or state consent, then we would even face a problem with this arrest warrant. So there must be something more. And I think it's fair to go back to the distinction of international and national tribunals that was laid down in the Eurodia decision of the International Court of Justice, and ask ourselves what could be certain international tribunals where immunities do not apply. And one avenue that was suggested, and that was already mentioned, would be the one of an establishment under international law on the basis of a bilateral treaty between Ukraine and the United Nations, whereby the United Nations would be authorized to enter into such agreement by a resolution of the General Assembly. Calling such a tribunal an international tribunal, and one that would be a certain international tribunal in the sense of the ICJ jurisprudence, would further develop that jurisprudence of the International Court of Justice, but would also be in line with the jurisprudence that we have from the Special Court of Sierra Leone in the Charles Taylor case, and it would also be in line with the ICC jurisprudence, in particular the Appeals Chamber judgment in the Jordan non-cooperation case. Now, certainly this was contested. But if we accept the premises, the legal premises that were made in those judgments, I think it is a valid case that can be made for the non-application of personal immunities by an international court. My second point, and now I'm moving from personal immunities to functional immunities, but also picking up on the idea of the unity of the law. The ambassador mentioned how aggression had a special place in the development of international law, the supreme crime in Nuremberg. But even if you go into the development earlier in the interwar period, the efforts to establish a criminal chamber at the time, or drafts of academic associations, they centered on the violation of the prohibition of the use of force, which was not called that way. But peace was the highest value that should be protected also by way of criminal law. So the crime of aggression, crimes against peace, are really at the center. Now we have moved away a little bit from that, partly because the world developed in a different way, where non-international armed conflicts became more important or more frequent, and answers needed to be found for those. But it's still there, and we should not treat crimes under international law, the four core crimes, differently in terms of the accompanying principles that we use in the field of international criminal law, that relates to universal jurisdiction potentially, that relates to the question of immunity, that relates to enforcement directly under international law. And I do see the discussions that are currently ongoing as a very positive development. So I'm very skeptical of draft Article 7 of the ILC draft not explicitly having an exception for the crime of aggression. And we know this was a controversial article. There was a vote to even get the article and any exceptions into the draft. But we also know that there was quite a number of explanations of votes of members of the International Law Commission that were very explicit that they did not support the non-mentioning of the crime of aggression in this draft. So I think, although we have a draft after the first reading, this is now tested in the discussion in the Sixth Committee with states that should take the floor and be very firm and voice their position. And I would expect in particular those states that do not support the creation of an international tribunal in the case of, aggression against Ukraine, but rather opt and argue for a solution that is based on national jurisdiction, to be very frank and very firm that there is no functional immunity for the crime of aggression under international law. And with that, very quickly to my last point, we are trying to close a gap. We are trying to close a gap for the prosecution of perpetrators of aggression committed against Ukraine, but we also need to have a look at trying to close the broader gap. Now we have conditions for the exercise of jurisdiction in the Rome Statute that are extremely limited. States agreed on them, not because a majority of states wanted those conditions, but because a majority of states wanted the crime of aggression to finally be activated. So it was a compromise. We need to live with it. It's not new that there is a huge gap, but I think the aggression against Ukraine has made it quite clear that this is not sustainable under international law, that we need to reconcentrate on the question of accountability and not on a discussion of who can escape accountability in certain cases. And I think in this spirit, we have a mandatory review coming up in 2025 of the aggression provisions, and I would hope that a majority or a large number of states, particularly 2/3 of states parties of the Assembly of States, of members of the Rome Statute, will speak up in that way and at least make a genuine try to rectify the situation and harmonize the exercise of jurisdiction over the crime of aggression at the ICC with the general jurisdictional regime that we have under the Rome Statute. Thank you very much.
Thank you very much, Dr. Reisinger and Coracini. Also, again, already for responding to some of the points that were made by the other respondents. So as you see, we're we're moving slowly into the Q&A. But we still have one speaker, at least if technology is with us tonight. So our last but definitely not least speaker is Dr. Owiso Owiso. He is an international lawyer, scholar and researcher whose primary interests and areas of specialization include general public international law, international criminal law and international criminal justice, international arbitration and dispute settlement, law of international organizations, human rights, and transitional justice. And he earned a doctorate in public international law from the University of Luxembourg and has taught at the University of Luxembourg and the University of Groningen. He's currently an independent international law consultant and a practicing lawyer, and he's published also on a variety of topics, including on an aggression chamber for Ukraine, supported by the Council of Europe. He cannot be here in person, but again, I much appreciate that he can still be part of this panel remotely. And let's hope, yes, I can see him. So, Dr. Owiso, you have the screen.
Well, thank you. I can see the screen from here, and it's indeed pretty big and intimidating. But I will pretend that I don't feel nervous. Well, thank you to the speakers who got before me, and excuse me, I have a bit of a cold. I had a few things to say, but having listened to the other speakers and Ambassador, I figure it's better to restrict myself to the debate around an international tribunal endorsed by the General Assembly versus one, the so-called internationalized or hybrid tribunal. A lot indeed has been written and said about the supposed virtues of an international model. While I find these conversations enriching, however, struck by how they or we often elide the political realities surrounding this quest for an international model. My first observation, and this relates in a way to what Professor Herik mentioned on the theme of unity, is the exclusive and unrepresentative nature of the so-called core group, which Dr. Korynevych also mentioned. This group does not, and this is the group that is at the forefront at the moment in driving the tribunal agenda. This group, the way at least in my estimation, it does not include a single member, and I could be mistaken, but it does not include a single member state from the Middle East or from Asia or from Africa, and only has about 3 members from Latin America. And to put it crudely, a majority of world states are either deliberately excluded from this process, or they themselves do not seem that much interested in this question of a tribunal, even though many, and I believe, are concerned with the invasion and its spillover effects, at least from the statements that they have released. They're concerned about this, but they don't appear to be much interested in the question of a tribunal itself. This indifference is also seen in the contentious litigation currently before the International Court of Justice between Ukraine and Russia, in which none of the over 30 intervening states are from the Middle East or from Asia or from Africa or from Latin America. This could be an indicator that a majority of states would want to avoid judicial confrontation. But again, this doesn't necessarily translate to support for the aggression, that is Russia's aggression against Ukraine. To be fair, we can't really blame these states for their ostensible indifference to the tribunal debate. No offense meant to Ukraine, but it has not done itself many favors in the past and in the present, and in this case, it's not different from any other state. International relations is primarily driven, at least the way I see it, by state interests. And as such, states have a very long and unfortunately, often unforgiving memories. So just a few examples. For instance, Ukraine doesn't have a very inspiring voting record at the General Assembly and the Human Rights Council on issues of particular relevance to some of the states. Again, Ukraine enthusiastically joined the illegal invasion of Iraq 2 decades ago. Ukraine's treatment of African and Asian students when Russia's full-scale invasion started 2 years ago was terrible, and we all saw that. And so was the poor treatment by Ukraine and its allies, specifically Poland and Italy, if I'm not mistaken, of the so-called Africa Peace Mission to Ukraine, and Russia led by the chairperson of the African Union and the South African president. So states most certainly remember these things, unfortunately so. So a quick glance at the General Assembly voting pattern on the issue of Russia's invasion of Ukraine is perhaps an indicator of how Ukraine is doing on the international stage. The record points to more abstentions than affirmative votes, even though these resolutions of the General Assembly were rather tame. And what I mean by that is they did not have much coercive force at all. It's therefore very unlikely, in my estimation, that in the present circumstances, that states who saw it fit to abstain in such situations would suddenly be enthusiastic to vote affirmatively for the establishment of a tribunal, which is indeed a rather coercive measure, at least in my estimation. It's one thing to condemn an obvious violation of the non-aggression norm, in this case, Russia's aggression against Ukraine, and it's a totally different other thing to support an international criminal tribunal for such aggression. So because Ukraine does not exactly have many friends outside Europe and NATO, one would expect that much of Ukraine's efforts should be trained towards winning friends where it has very few. Instead, it appears to me, and I could be wrong on this, and I hope I'm wrong, that not much effort is being put towards reaching out to states outside the EU and the NATO bubble as regards a tribunal, the specific question of a tribunal. I've fortunately or unfortunately spent quite some time these past couple of months interacting with diplomats from some of these capitals in the line of my work, and many of them confirm that they haven't been approached on this question of a tribunal, at least not with any degree of seriousness. This then raises the question of who really is considered important in this conversation. So to my mind, if indeed Ukraine and other supporters of a tribunal endorsed by the General Assembly really are serious about getting this model off the ground, then a change of tact is necessary. And by this, I mean that there should be serious rapprochement with the Middle East, with African states, with Asian states, and with Latin American states, grounded, of course, on mutual respect. Having said all that, I must emphasize that I'm of the opinion that the General Assembly route for establishing a tribunal is most likely doomed anyway, and I apologize for being a bit of a pessimist in this regard. Most UN member states are unlikely to go down that road because that would be a precedent that leaves every state potentially exposed. This is in fact an issue that could cut across ideological and geographical lines, the so-called ideological and geographical lines that define the global system. So political and military powers such as the United States, China, and Russia would most certainly not want such a precedent. And neither would lesser powers like France, the United Kingdom, India, Brazil, and Japan. Suddenly, more states from both the so-called global north and the so-called global south would not want such a precedent either. It's perhaps because of this realization that Ukraine isn't reaching out much beyond the EU and NATO, and I would understand if that is indeed the motivation. Granted, I do acknowledge that a tribunal endorsed by the General Assembly would perhaps enjoy more or much greater sociological legitimacy than, say, a tribunal established by treaty between Ukraine and the Council of Europe or Ukraine and the European Union. This, however, only holds if the General Assembly resolution establishing such a tribunal is passed by a significant majority of UN member states. But as I've said before and previously, this is rather unlikely. The likely scenario, if this becomes a reality, is that in reality, only a bare majority of UN member states would vote for this, since the resolution would only require, I believe, 2/3 majority of those present and voting, not of all member states. The result would be a tribunal that does not enjoy wide global support, and one that could, I believe, be haunted at every turn by the political divide that we see among UN member states. In this case, then, one wonders, I certainly do wonder, how much more legitimate would a tribunal not endorsed by a majority of UN member states be than one established, say, by treaty between Ukraine and the Council of Europe or Ukraine and the European Union? I most certainly would not begrudge Ukraine its legitimate desire for a Nuremberg moment, and far be it for me to minimize a victim state's right to have a say in how its oppressors are held accountable. Ukraine has every right, I believe, and I emphasize, Ukraine has every right to have a strong position on this question. That said, it's encouraging to see that Ukraine's stance regarding the model for a tribunal has sort of softened over the past couple of months from a very strong anti-hybrid model to being more receptive to exploring or at least discussing all possibilities. I think at least we saw this during the lecture given to students at Leiden by President Zelensky. So diplomatic realities aside, this, at least to my mind, points to a reconsideration on the part of Ukraine of what the goal here really is. And that goal ought to be, at least in my estimation, accountability for the crime of aggression and not merely seeking symbolism. In this case, by symbolism here, I mean a Nuremberg symbolism. It's the realization that insistence on a specific model, which itself may be impossible to adopt, only serves to derail any genuine efforts towards the goal of holding the Russian political and military leadership criminally accountable for the crime of aggression. It is also perhaps realization that justice does not become of a lesser or more superior form depending on the mode of establishment and the design of the mechanism dispensing it. So in conclusion, I would say that in times of political crisis, like in the instant case, political and diplomatic realities may mean that the path of least resistance, or more accurately, the only practical path available, may very well be the one that delivers much needed accountability. I'm speaking here of a hybrid or internationalized tribunal established by a treaty between either between Ukraine and the Council of Europe or between Ukraine and the European Union, thereby in the process bypassing the political mess that is United Nations politics. There is already, I believe, a significant political appetite within Europe for this, especially at the level of the Council of Europe, if you look at the several resolutions adopted by the Assembly. As long as this path is legally legitimate, and I see no reason why it shouldn't be, there really is no point, in my opinion, splitting hairs of a practically impossible ideal of a General Assembly endorsed tribunal. In short, there are viable options, and I believe that we should be receptive to them. So I think I'll stop here and yield the floor, well, or more accurately, yield the screen back to Dr. Paulussen. Thank you. I hope I haven't taken too much of your time on this.
Thank you very much, Dr. Owiso, for that more critical perspective, but that still has indeed relevancy for the discussion on how many states Ukraine can rally behind the establishment of the International Tribunal. Before I turn to you, the audience, I would first like to give Dr. Korynevych the opportunity to respond to all these ideas and suggestions and criticisms. Maybe a little bit short in view of the time. Thank you.
Yeah.
We still have the reception, by the way, where we can informally.
Thank you so much, Dr. Paulussen. Yeah, I'll try to be short. though of course it's a very productive discussion with great ideas and important ones. So very briefly, but I think really important issues for us to think about. I really enjoy and always think about the issue of unity on accountability. And I think that when we talk about accountability for the crime of aggression and the issue of establishing the special tribunal, some of us may already think about differences, like this state supports variant A, that state supports variant B. But I would draw your attention to another point, that a lot of states, including those which are in core group, they are united by value and principle that there must be accountability mechanism for the crime of aggression. This is something which we couldn't imagine several years ago. And some states really changed their position from definite no to yes, let's try to see how it can be done. So I would point out and draw your attention maybe to think more about unities and differences. And we have this unity. And that is why I'm sure that this would be important for us to reach this goal. Maybe this is happening for the first time after World War II, such a unity of principle and value. I really think that the issue of immunity is in principle left for the judges to decide. So because we cannot here on or in any other room with anybody else decide what the court will decide when it is established. So this is very, very important notion. Concerning national prosecution of the crime of aggression, I also believe that we need to talk about leadership element. Though in National Criminal Code of Ukraine, Article 437 is a very broad one, and it is a post-Soviet legacy. And it is quite the same as in other states which were part of USSR. So I'm sure that such instruments as ICPA should be concentrated on the leadership element of the crime. Even inside this broad definition, I think it is possible. Let the broad taken by the normal national courts, yeah, and ICPA concentrate on the leadership element. So, and I think that really we all here understand crime of aggression as a leadership crime. I think that it's not a matter of some differences between us. As an international lawyer, I of course understand that there should be no difference between 4 core international crimes. And if the ICC is amended, let it be. So again, while we are advocating for establishment of a special tribunal for the crime of aggression against Ukraine, we are saying that we need to close the accountability gap for this particular situation. If ICC, if the Assembly of State Parties will decide that, no problems at all. Of course, if we would be able to go to the UN Security Council, it would be the ideal version, but we cannot. And since there is no this ideal version, any variant which will be chosen will not be ideal. Any of us will be able to sit here and say, look, there are some discrepancies, there are some problems in variant A, variant B, because no one will be ideal. But I think that, but remember, President or former President Slobodan Milosevic was beginning his defense here in ICTY saying, this court cannot try me, it doesn't have authority. So I think it's a very important issue. And really in our lexicon, we try to use the wording, not if the tribunal is established, but when or how the tribunal is established. Broad support of the international community, of course. So believe that nobody in Ukraine, in Kyiv, wants selective justice. We are not here for that. We understand that our tribunal will need this broad support of international community. And in relation to the Council of Europe, I think this is an important issue. As long as we see how it goes, I think that the Council of Europe may be a very important partner and expert platform to assist in establishing and functioning of the tribunal. But this may be its role, and I think Council of Europe concentrated on this in its documents. I, of course, will also figure out or talk a bit about the core group participants and ICJ allegations of genocide cases, 32 interventions. If somebody in this room can tell me which case in the ICJ got more interventions, I get you a beer. I don't think that you will find any other case with such a number of interventions. Everybody wants more. We also, but we do appreciate role of each and every intervener, and we consider that this is a big number, and it's important. I think that it's rather hard to comment on how Ukraine performs on international arena. I think that we show how do we perform, and don't forget that when I return to Kiev, we have an enemy which wants to wipe us off the map. So it's an important argument in our life. I think so. Regarding the softening of position of Ukraine, this is something what I think we need to figure out also as lawyers, that there may be positions which are sounded, you know, but we always understood that we need to explore options. And that is why we are there with core group participants. That is why we talk about this. We understand that we need to find a solution. And when you want to find a solution, you talk and you hear, because this is a way how it is done. And I think here I will stop. And no, once more. And in relation to the draft Article 7, I do believe that the states who are in favor of supporting internationalized tribunal should support that there should be no functional immunity for the crime of aggression. This would be a natural thing. Thank you.
Okay, thank you very much. We have maybe time for one or two questions, just a few, and again, there is a reception, so you can ask your questions as well in a more informal manner, but a few practical points. So please raise your hand. When you get the mic, please state your name and affiliation, as well as the person you address your question to. This probably goes for just one person that I'm now going to explain, but I'm going to do it anyway. So please make use of the mic, otherwise the people online and in the other room here at the ASSER will not be able to hear you, and please keep it short and concrete as possible. And please also know that this lecture is being recorded, and if we obtain the consent from all the panelists, we will upload this lecture online to the ASSER website. So you and your question may appear online, so just good to know in advance, I would say. And finally, my colleague Gabriela Radu is following the chat online. So if you're watching this online, not sure where to look, but please write your question down in the chat function. So having said all of this, to whom can I give the floor? We have two mics by Belén Guerrero and Ana Maria Negria. Yes, Fabrizio.
Thank you very much. My name is Fabrizio Guariglia, the director of the Hague Office of the International Development Law Organization. I have one quick comment and one question for Larissa van der Herik. The comment is, I think that we talk about, you know, the impunity gap that not having an aggression tribunal can create, primarily because of the issue of immunities. And I would like to highlight that if we don't have aggression, we are stuck with conduct of hostility crimes, which are much more difficult to establish in evidentiary terms. And we will be able to peg only some players within the higher echelons of the political immunity apparatus to the devastation on the ground, whereas we could probably attribute aggression to some of those players. So the consequences in terms of impunity gap of not having an aggression accountability mechanism are much wider, I believe, and they're not restricted to the issue of immunities. But if I can go to the issue of immunities, there are probably wider consequences if the draft ILC articles go forward in terms of accountability for aggression, because it's not only the fact of functional immunities and personal immunities, it's also the procedural consequences. There are a number of procedural obstacles that can also hinder an investigation of people that are covered by functional personal immunities if those articles go forward as drafted, which means that I think that it is critical that whatever mechanism is created, whatever tribunal is created, has sufficient legitimacy to at least be able to trump in one way or another aggression, to at least permit what Professor Nollkaemper referred to as partial accountability for aggression. And there is my question for Larissa. We think that with UN-backed models, like the Special Court for Sierra Leone, for instance, we could be more or less safe. Now, at the other end of the spectrum, we have the Iraqi Special Court that was supposed to be a hybrid tribunal, and it ended up being something that basically no one could consider to be very legitimate in international terms. If we move away from the UN-backed models and we get into the club of states, as you refer that, what is the turning point? How much representativeness do we need in order to be in a position to really say that it is international enough within the terms of the ICC appeals chamber in the Bashir case to be able to claim that immunity does not apply to it.
Thank you. Would you like to respond immediately? Thanks.
Yes, maybe. Thank you. And I think actually your question goes to the heart of the point that I was trying to make. So I was not necessarily saying that the law as it is today is such that there is no immunity, personal immunity for an international national tribunal per se. But my main point is that we are focusing on mode of establishment or creation, international versus national, as the defining element, whereas international is not one model. It's a whole variety of models. So I think we need to refine the argument. And I think the key element for the discussion of personal immunity is not international or national legal nature of the tribunal, but it is precisely this international endorsement. That is the criterion. And so conceivably, that can also be with a tribunal that is international in some sense, but that is rooted in a domestic sense. I think you can make that argument, provided that there is sufficient international endorsement that meets the standards of customary international law, so significantly widespread and representative. And then, of course, we do bump into the creation that the obstacles that were mentioned by Dr. Owiso, that we don't have that. So I think the energy needs to go there rather than repeating again and again the nature of the tribunal. I think that's really where the energy must go. And then on impunity gap. So in June of this year, I had the privilege of visiting Lithuania. And there, we speak here in The Hague a lot about culture of impunity. And there I heard a lot this sentence, history of impunity. And of course, a very lived history of impunity, which I think points really to the need of having this tribunal, of ending that history of impunity. And I don't know if I may, but we have the Deputy Minister of Justice of Lithuania here, Dr. Gabija Gavia, yes, who I think is also a very important voice in this. So I don't know if you would like to add something to this.
Please bring the mic. Thanks. Otherwise, you'll get mine here. This will work too.
Yeah. No, it's okay.
It works.
So
Yes.
I'm sorry that I sit backwards to all of you, but okay. I have to listen to the others, that make me stand. But first of all, nice to meet you all. And thank you for inviting us to be here, because I think it's always good to have good timing, and as you all perfectly know, tomorrow we have core group. So to have such a discussion just in the evening, it's, I would say, good, sense of events happening around in The Hague. And then, I was listening to all of you and understanding that in the core group, we actually have very tough discussions. So I wonder, if we have all of you moved, to the core group, that would be even more fun. But, we feel our responsibility. And I will first make some comments on the things that I've heard. And then I will have one question for the panel. So maybe I would start from the last one, from the history of impunity. And of course, it's not secret, that Lithuania, we were occupied by the Soviet Union, and the second occupation lasted for almost, half of a century. So we know that, administration of justice in time is very, very important, because now if we want to have the issue of occupational damage, the question that we get is, so where is the legal ground for that? We agree that we have been occupied. We agree that, we lived in many years of injustice, but we don't have, legal decision that would say that actually, Soviet Union was responsible for that. So that is why we always say that if we do not act now, because, we had Georgia, We had Crimea, now we have, you know, full-scale invasion. So afterwards we have Baltic states, because if we wait, you know, that Putin steps down, so I think, you know, the natural ending might be, you know, sooner, because, you know, if you allow him to regroup himself, you know, if you don't send the clear signal that tribunal is waiting for you, he will not stop. And why? Because he has that huge ideology, you know, behind him. And we have to agree that one of the important things that Nuremberg did is that it condemned the ideology itself. And if we have, you know, hybrid tribunal, it would not be able to condemn, you know, Russian world ideology, because it is, you know, the broad issues to be there, you know, and to be sort of managed on the international real institution that actually reflects interest of international community, that such ideologies against international law, you know, from the very primary, you know, primary source, I mean. So now I think coming back to the core group, I think the good thing is that all the states that are in the core group, they realize their responsibility, and they understand that making history in the end has to be done in the right way. So if you want to do it in the right way, you have to think about many things. But when you start thinking about those different, you know, aspects that you have to go through in your head, you understand that when you speak about international hybrid or internationalized tribunal, you immediately have that feeling that you understand that international, you know, courts and international fully fledged tribunals, the nature that we have and the consequences that we have are totally different from the ones that we can call them whatever we want. But, you know, even if you take international doctrine and you see what cases have been quoted as having influence on the development of international law and international criminal law, so what? You have most of all, I mean, international tribunals, because you understand that the decisions that we make, the power that we exercise that has been, you know, entrusted to them, this is the international interest of all of us, you know, of all the states. So I think that is why in this case, you know, when we discuss about the models, and yes, like multilateral treaty or whether it is internationalized court, the problem is that we perfectly know that in this case, it could be easier to make it legal than to make it legitimate. Because, you know, Ukraine could enter into treaty with Lithuania. We could have Vilnius Tribunal, but, you know, to sort of solve all the problems out. But we all understand, you know, that we would immediately have the issue of legitimacy. And what I always say, you know, international law is not about, you know, academics, academic books, you know, and saying that it cannot change, because I think the value of the law is that it is able to change when the context demands it to change. And, you know, international law is created by states. So I think that in this moment, the creation of a tribunal, it actually touches upon the rules of international law. I think that was obvious today, whose interpretation is neither uniform nor universally accepted. So if we do not use this momentum to make sure that we have a development that we must have, so that the crime aggression does not, you know, disappear from international criminal law. So I think we have to act now, and we have to act as international, as legitimate as we all can do. So I'm sorry for that long, you know, remarks, but the question that I have for the panel, referring back to the things that I started with, is that tomorrow we have a core group, as you perfectly know. So what is one solution that you would send to the countries meeting and continuing discussions on these two models? Okay, so that is my question, and thank you. And nice seeing that much young and motivated people here. Thank you.
Thank you very much, Your Excellency, for this improvised intervention. I think because of the time, we're already 15 minutes late. I suggest that you already reflect a little bit about what kind of suggestion to give. But I know that there were some other questions as well in the back of the room. But again, we have the reception where you can ask these questions as well. I think this has been a wonderful, well-attended and productive evening. And I would maybe say the subtitling would something be like in search of unity, because I think that was the central concept. I would like to thank the Ukrainian Embassy, especially Ambassador Mr. Oleksandr Karasevych, as well as Maria, Ms. Denishna, for co-organizing, co-hosting this event, and would also like to thank the Municipality of The Hague for their financial support. Thanks also go to the IHCL Platform, my colleague Gabriela, for monitoring the online chat, as well as our events team, in particular Eva de Costa, who's chasing me now, as well as Alexandra Pinto Damas and Alicia Garcia. And would of course also like to thank you, the audience, for coming in such great numbers and for your good questions. And finally, and most importantly, please join me in thanking the keynote presenter, Dr. Korynevych, and our distinguished panelists, Professor Herik, Professor Nollkaemper, Dr. Reisinger Coracini, and Dr. Owiso for their insights. And this is definitely not the end of the discussion. ASSO will continue to host closed and public meetings on this important and developing topic, but also other topics. The next SCL is on the 18th of October. That will address domestic accountability for international crimes.